I'd like to call to order the special meeting of the Town of Rhinebeck Planning Board for Monday, May 16th. The purpose of the meeting this evening is exclusively for the discussion by the Planning Board of the revisions that are being recommended by the Zoning Law Review Task Group, which is comprised of the town supervisor, the planning board chair, the vice chair, the ZBA chair, the land use attorney, the CEO, and the planning consultant. We have been meeting over the past 4 months as the planning board is charged with periodically making recommendations or revisions to the zoning law. And we have met, discussed the issues, and proposed measures to, 1, correct errors or oversights in the drafting of the 2009 zoning law that have become apparent as its provisions have been applied. 2, to clarify certain other provisions. And 3, in doing so, to simplify and otherwise facilitate both the understanding and compliance by applicants with its provisions and by town officials, including the ZEO, Planning Board, and the ZBA in its administration. And so we're here tonight. You all had an opportunity to receive the final draft as prepared by Art and submitted to the town. So, Art, do you want to go through briefly the schedule, the upcoming schedule?
I will add to that. You said as prepared by Art and submitted to the town board, and along with the introductory resolution and EAF Part 1 processed by the town board at its meeting on May 9th. The processing by the town board included accepting introducing the proposed local law, referring the local law as required to this planning board, to the county planning board, to the CAB, and to the Waterfront Advisory Committee, directing the town clerk to take care of the administrative details with respect to publication, notice, etc., including notice with respect to the public hearing that the town board has scheduled on this item for June 13th at 6:45 p.m. So that's essentially where the matter stands. I really have little to add to the summary that's provided in the resolution of what the intent was of the zoning law review task group and what the substance is of the amendments. We're dealing with corrections, clarifications. There are no matters involved here that go beyond what was considered by the task group and accepted by the town board as housekeeping. There are not any policy issues being decided here, being proposed for decision. There are no changes in the zoning designation of any lands except for one correction where there was an error in mapping back in 2009. So essentially this is an exercise in cleanup and making it easier for applicants to work under the law and for the town officials, including the ZEO, the planning board, and the ZBA, to administer the law. I think you'll find that many of the items that are dealt with are matters that have been discussed here at the planning board as individual applications have come before the board over the years, ranging from such topics as what level of review or what multiple levels of review should be required for things like an emergency generator or a fence or what have you, and whether there should be some adjustments in the provisions related to accessory structures, as a for instance. It's those kinds of things. Beyond that, the only other changes, I'd say, that are driven by outside forces would be the incorporation of various definitions and regulations that are were provided for in amendments, 2011 amendments to the New York State Agri-Markets Law. And those need to be incorporated in the local law with respect to the specific definition of certain agricultural sorts of uses and activities. So that is taken care of, and probably the most dramatic provision in terms of application of the law down the road, if these amendments pass, is the clarification that it was the intent, and now the express language of the proposed would be the express language of the law to accept the concept of grandfathering as generally practiced for the last 100 years under zoning. But the bottom line is existing non-conforming uses, existing non-complying bulk with respect to area setbacks, number of accessory structures, etc., are not matters that are intended to require an approval by the planning board, a variance by the ZBA, or any other body. That these are existing conditions that, if they legally existed at the time of the adoption of the zoning law in 2009, are allowed to continue indefinitely, provided, one, they continue to operate in a legal, workmanlike fashion, and two, any modifications, enlargement, expansion of those uses is within the parameters that are established by the zoning law. There are certain opportunities for a 50% expansion of certain non-conforming buildings and things of that sort. So the bottom line is to accept grandfathering within the limitations that are provided within the law. I think that's a quick summary of what we have here in terms of intent. The committee, as pointed out in the narrative which accompanies the draft local law, did identify a number of items that fall beyond the scope of housekeeping. These are topics that should be addressed at some point in town by the planning, not by the planning board, by the town board, in essentially perhaps zoning review 2. And those are matters that do involve land uses and policy matters, and matters of institutional capacity within town hall to administer the regulations in terms of personnel or technical equipment or what have you. That's
all right. So at this point, I hope you have...
and let me just say one other thing. In addition to the work of the task force, there was a request for independent review at 2 occasions of the document before it's reached this point by the town attorney, Warren Raplansky. Of course, the planning board attorney, John Lyons, was part of the group, and council persons were also provided the opportunity to provide their input. I would say that in every case, not all of the input that was provided by those individuals could be accommodated, because in some cases there was conflicting positions being taken by people with respect to individual provisions, be it the 50-square-foot rule or what have you. One of the council people, as for instance, said it should be a bigger number. And what I employed in my last draft, and was accepted by the task group through my last draft, is that if there was a matter of law or interpretation of law involved with respect to the question, the opinion of the town attorney prevailed.
What was that?
the opinion of the town attorney prevailed.
If we were getting conflicting comments
Yeah.
from members of the town board, for example, and the town attorney, Art, in resolving that, came down on the side of the town attorney as a matter of law. Now, the town board, in going forward, obviously has the authority.
Yeah, I mean, the attorney is a consultant.
That we're just saying by virtue of moving it forward, that was his
By
approach.
by virtue of, I guess, Richard, by virtue of more than simply verbal opinion, but by opinion supported by case law.
I would hope that our town board and this board would also pay attention to our attorney, but, I mean, I would...
As supported by case law.
I know, but I'm trying to understand your statement. You would, I mean, the town board will either accept or not accept the opinion of their counsel.
The council has reviewed.
They have not yet officially, have they reviewed it?
Council has reviewed the document to the extent of saying the document is adequate to move forward as an introductory local law. Council may have further comment.
Okay.
And that negotiation will take place ultimately between the town board and the council.
And council. And it's beyond the work of the task group. Essentially, this document has gone beyond the task group to the town board. And that's where any further consideration will lie, except for the matters of the required referrals. And that will be input that's considered by the town board. And
they have scheduled a public hearing?
Public hearing is Monday, June 13th, 6:45 p.m.
So that will initiate the public hearing part, the public process. And I assume that Warren will be looking at it on an ongoing basis as the public weighs in as well. So our purpose here tonight is to have all of you weigh in with any comments on the document as it's been shared with you, in terms of thoughts you have, suggestions, errors, omissions.
Just to finish with the process, going forward, I mean, by our own law, we've said every 3 to 5 years we will go back and amend and fix them. But the truth is, it's really an ongoing thing. Maybe we only need to pass something every 3 years, but it's really a collection of, let's put that down on our list.
And that had been ongoing. I mean, I know that when Michael Trimble was the chair, he and Elizabeth had met 1 or 2 times to begin to make lists of things that were problematic. Art has been keeping a list for some time. Yep. I think each of you independently, whether you were making a list or not, had your own list in your head of things that you saw were causing roadblocks or problems. So you're correct. We should.
It'd be nice to have a centralized list, though, so that I could throw something on a list and you can say, get lost, that's a bad idea, or embrace it and say, yes, absolutely, that's going to save us a lot of time, or it's going to make the process a little easier. Just a thought going forward, that's all.
Richard, at least that's where this particular process, part of the process began. It began with a meeting in December of the task group, and we started just tossing around, well, there's been the concern here, this concern's been expressed, that concern's been expressed, etc. And what we did at that point is we assembled from anyone's notes those lists, those informal lists that had been created, like the one that Melody said that Michael had at one point in time. I'd been developing a list over time. We talked to the ZEO, et cetera. I think Elizabeth had a few items on a list that people had communicated with her. All of those lists were essentially...
So it's just a matter of, right now, submitting your list to whoever the collector is.
And I said the only way to begin this, I said, I'll take all those lists, plus any additional concerns that I've been made aware of in terms of communication with this board on a monthly basis and with the ZBA, and put that together in a working document. And that's how we began in January. That working document has gone through, I think, 4 iterations since then, to the point that it is now the document that's before the town board.
May I make a couple comments?
Sure.
I've crawled through this documentation a few times, And what I find is it's an outstanding piece of work. I want that on the public record, okay? The people who were involved in it did an outstanding job. It's, in essence, captured what a lot of us have been concerned about for a number of years, where there's been no activity to create fixes for them. Now looks like we're going in the right direction. And I would encourage the town board to make sure that this happens, because it's very necessary for this community. We've had a lot of unhappy applicants. We've had a lot of unhappy board members doing excessive work, and I think this will streamline it. And what you have here is a new set of laws where it takes some common sense into the whole approach, and it allows some spirit of the law to be interpreted instead of the letter of the law. That's it.
Okay. Eric, do you have any comments?
Not right off the top of my head.
Sharon, anything you want to add?
Nope.
Edna?
Great job. I agree with Woody.
Thank you. Richard?
Are we going to talk about the items? No one has any comments about any of the items in here?
Well, that's what we're asking now, on any of it?
This is the time for you as planning board members, and I did send out an email asking you if you had substantive comments to share them with us in advance, so we all had a chance to look at them.
Well, I have comments, I have concerns.
But this is the time for you to express
Well,
them.
I preface my statement by saying just on the organizational level, but yes, I have comments. In the paper that I received with the changes, page 11, number 4, in all zoning districts, except HP 20 and RA 10. All roofs otherwise enclosed accessory structures except for agricultural buildings shall be aggregate comprise not more the floor area than the principal dwelling. So you can't have an accessory structure larger than your house, the primary structure. Yet within the HP 20 and RA 10 you can. So if I have a 1,200 square foot house on 20 acres, we're permitted to put up a 6,000 square foot accessory structure.
That is correct, under the proposal.
I want to clarify, I think that's a little excessive. I mean, the spirit of number 4 is so that you don't have this monster garage next to this little house. But the same doesn't apply if you have enough property.
Sounds reasonable to me.
Pardon?
Sounds reasonable to me.
What if you have a 20-acre farm and you want a barn, you know, you don't want to restrict
Well,
it to the
that
size.
falls under the agricultural clause, so that's not an issue
Not
for
necessarily.
that. But this is, I'm talking about, well, the RA 10. So you have 10 acres, which isn't an enormous amount of property, but still the same scenario. You have a 1,200 square foot house or 1,000 square foot house, and you next to it you have a 3,000 square foot barn. Doesn't that defeat what this is trying to do? Why not put the same limitations? Why not put the same limitation of the principal dwelling on the larger properties?
All right, moving ahead with your comments.
Okay.
'Cause, let me just say, we're here to receive
Yeah.
comments tonight.
Well, that's why I'm saying.
amending
Okay.
this.
Down the bottom of the page, additional accessory structures may be cited if a special use permit is granted by the planning board. It almost sounds as though we're doing the zoning board's job. Wouldn't additional accessory structures may be cited? Doesn't the applicant have to go in front of the zoning board for that?
Which item are you at?
6.
Number 6, last couple lines of the page.
Yeah, that's an existing provision of the law. The only addition is that the clarification here is the words "by the planning board" are inserted. All special permits are issued by the planning board, and that's just clarification that if somebody looks at this, they know where to go for the special permit. That's an existing provision. It's been applied in the past. It will, but only on lots in excess of 10 acres.
The permit
Again,
is granted by the ZBA right now, right?
No, No, not on a lot of 10 acres. Again, if the language here is not underlined, that means it's existing language of the law.
Well, I know, but the fact that you added by the planning board is what my
Just to
concern
make it
was.
clear that you go to the planning board.
As opposed to the
Does
ZBA.
There is no other special,
And that's
ZBA
only
does not have
granted by the
special
planning.
use permit authority under
So they still have to go in front of
No,
planning board.
the planning
the
board.
zoning board for additional, if they
If-
go past the number of accessory structures.
The way the ordinance is written, I'm not saying necessarily how it's been applied. Under the zoning law as written, you do not have to go to the planning board for additional accessory, you don't go to the ZBA for additional accessory structures if your lot is in excess of
Okay,
10 acres.
just
If it's less
commenting.
than 10, you have to go to the ZBA.
Just commenting, I'll move on. Page 13, modify subsection A in the manner set forth, fences, gates, and walls. Down the bottom it says, and forestry uses, any fencing, which exceeds 6 foot in height or which consists of a solid fence or wall that does not allow passage of views. The addition of any, what was the spirit of the addition of any? I mean, it sounds to me like if there's a 4-foot solid fence, it falls under this category.
That is true. That's the existing regulation. Any fence, fencing which is either greater than 6 feet or fencing which is a solid wall under the existing regulation, and it's, that is not changed. The any, I think, is a redundant term, but it was specifically requested by someone that it be included, and that
Okay.
request is being
So,
done.
but a solid 3-foot fence in front of his front yard to
That's
keep your
the
dog or
existing-
child in?
That's the existing provision. And we did discuss whether or not that should be modified, and it was the opinion of the group that it should not be modified.
All right, well, I mean, it can certainly stay on a list somewhere. It will stay on my list. Page 15, section 12557. Existing. I won't bother you with that. Well, you know what? We're here to make comments on changes that we're proposing to put. So I wanted to go on a list. I want to go on record for saying I'm not sure why, as determined necessary by the planning board, is appropriate. Do we have a set of criteria for parking lot design?
You do. You have about 3 pages in the zoning law.
Okay, so we're
Actually,
determining the
yes.
design standards of the parking
Yeah,
lot.
the
Okay?
parking, those standards are very explicit in the zoning law.
Page 17, underlined towards the top of the page, both reviewed by the ZEO not less than 21 days prior to the meeting. And it says, I mean, these sound like, and forwarded by the ZEO not less than 14 days. Forwarded to the planning board, I'm assuming.
Yep.
But this is a very internal housekeeping thing. Why in our zoning law? I mean, what if Ron doesn't pass stuff up here? Do we whip him?
I'll just start off with the change that's proposed here
Yeah.
is basically that applications have to be submitted to the ZEO 21 days instead of 14 days before the meeting in order to allow the ZEO the opportunity to review and forward to the planning board by the time of the planning board deadline.
So at least he has the opportunity for
That's
us to
right.
have it 14
That's
days. And if he's on vacation or whatever the case may be,
You make a special, that can be worked out on a case-by-case basis or whatever, but as a general rule, it's to provide that opportunity for the ZEO to look at an application and forward it to the planning board.
okay.
As opposed to the planning board it coming into both parties simultaneously and the planning board putting it on the agenda and then finding out that the ZEO says, hey, no, that's not acceptable.
Okay. 17, bottom of page, delete in its entirety subsection E. Subsection E seemed to me to be kind of like a safety blanket for us. Whereas the planning board may waive specific requirements set forth, we don't have to do anything, we may.
This is with respect, 12568 deals with the specific additional standards that relate to individual special permit uses, and the planning board does not have the authority under any other zoning ordinance or case law to waive special permit standards. And this is one that, frankly, the town attorney said, I wonder how that got by me in the 2009 draft.
Okay.
And Melody was there for that discussion. Yeah.
Failure, page 18, middle of the page.
Yep.
The
failure to render a
failure
decision?
of the planning board to render a decision. What happens? So we're telling the applicant when they submit something that we will have a response for you within 62 days of acceptance of the complete application. So then we turn around and say, oh, we didn't make it. We didn't make a decision. So we're saying now, if we don't make that decision, it doesn't mean you get it automatically. I get it.
The bottom line is that there is no such thing as an automatic approval under zoning.
I understand.
Unlike under the state town law with respect to subdivision, where if an action isn't taken within 45 days or 60 days or whatever, you actually can go into the town clerk's office and get a certificate that says you're approved by virtue of the failure of the planning board.
Okay.
There is no comparable provision in the enabling legislation.
But we are making the statement that we will act on it. It will be made within 62 days. Why make that statement if you're going to say, if we don't, nothing, you got to wait for us.
Okay, I'm going to do it again. With respect to the planning board action here and later with respect to the ZBA action, language specifically added at the request of the town attorney.
Okay.
And the planning board attorney. And the planning board attorney.
Okay.
Yeah, this one I could say and planning board attorney.
Top of the next page, the end of the planning board may require a resolution of approval. A special use permit be renewed periodically, typically for a period of 3 to 5 years,
Yep.
and in consideration of land uses such as mining, where jurisdiction is shared by the town, county, and state agencies. I get that, and I don't think it's a terrible thing. I think it's a good thing. What happens when you have the county already requiring the renewal of permits? And are we going to say, well, we want you to come and renew, and we want to renew and review too, like the mining out on Slate Quarry? Now, the county already does that. So, A, are we subjecting the applicants to 2 reviews and 2 application processes?
The feeling, the general opinion regarding establishing a timeline on a special permit is to do so only in cases where there are other agency reviews involved, like the county or state review of the mining situation that you pointed out, to provide the planning board or some other town attorney agency, generally the planning board though, the opportunity to concurrently review the renewal.
So
which is the practice with respect to mining.
So do we let them run as the lead agency? Is that the intent of this? And we are a participating agency and a contributing party?
Actually, if it's mining, DEC insists on being the lead agency.
So we would be, ours would be an opinion, and we have this.
And a renewal is not a lead agency to a situation. A renewal is a ministerial action under seeker, and therefore is exempt from seeker review.
But we would be tracking that, and that would become something on our radar at all times. Okay. And there's a list of those kind of things that's circulating around, what we're going to target? The question at this point in time is that what are those items? The only 2 that really come to mind in my particular, for me, are mining and realty subdivision approvals by the health department. Those also have a sunset provision. But when we make a statement like this, don't we want to quantify it by saying it will affect this in our zoning law?
At this point in time, we believe mining is probably the principal item.
Right, so I would expect to see mining in there, but we're saying...
And mining is used here simply as an example of such as mining.
Okay.
Where there's shared jurisdiction.
So, but when we pass this and we say, yes, we agree, that's great, let's put that in. After the fact, do we come up with a list, say these are the special use permits, or is it all special use permits? We just decide which ones we want to do
I think you, as you would issue a special use permit, if that special use permit included the requirement for approval by an outside agency, you would then consider whether or not you wanted to include a renewal provision
Within your resolution.
in the special use
So that's
permit.
during the application process
Exactly.
and the
Exactly.
Be included in the
Because I think it
Granting
would
of
depend on the magnitude of the action involved, and the magnitude of the permit consideration by that other agency. If it's a simple stormwater speedies permit or something, you wouldn't want to do that.
Okay. Moving on. Page 22. Sketch plan conference. We had, after we passed our new zoning laws and everything, this new concept of sketch plan conference where initially the applicant was supposed to come in front of the board with a very simple rendering and pinpointing a specific list of characteristics, stone walls, large trees, streams, structures on their property so that we could get a feel for the project and make sure the applicant had a feel. I feel like pre-application and sketch plan conferences, both of which seem to fall into private meetings with the chair,
No.
the planning consultant, and the other heads of departments. And all of this happens before it ever even comes in front of the board.
That section 12574 covers two items: pre-application conferences and sketch plan conferences. Pre-application conferences are essentially the initial meeting that's described here. This is basically reinforcement of a procedure that's existed now for 6 or 7 years, but less than clearly stated in the law. The sketch plan conference is separate from that. The sketch plan conference then would follow with the planning board in terms of a major site plan or a subdivision, which is covered in another body, another section of the town code. The sketch plan conference with the planning board is what you're describing. That, in fact, is what happened, for instance, with the Marion Rue project very recently. They came into the board at sketch plan conference prior to applications. Post pre-application conference with the group prior to formal application to the board. That plan was brought.
I agree. But in general, now, there was specifically a clause added that says the chair, the planning consultant, and other persons who may be designated by the chair. Is the applicant picking up the cost of the planning consultant for this new pre-existing pre-application process?
Pre-application conferences are specifically covered by the escrow agreement. There are no pre-application conferences scheduled or conducted until a escrow agreement has been signed and an appropriate deposit made.
And there's a specified fee for a pre-application
Yeah.
conference.
So there's an additional fee in the process. You're putting in the application fee, but
It has been.
It has been all
Yeah.
along.
what's the pre-application fee
I
cost?
want to say
It depends on the nature of the application. There's a different fee between small-scale residential and commercial projects. Is it 150 and 300?
it's something like 150 or 300.
Okay, and the other
No, 300.
interested parties, whether those be...
The most typical other party would be a determination essentially by the chair, at the discretion of the chair, that either the planning board engineer or the planning board attorney should be brought in at the pre-application conference.
I have a question. Can the chair waive that requirement for example, a very simple application to join two lots or something like that?
If you look at the note that always appears on the agenda, where's that note? I thought there was except in the case of subdivision applications involving only lot line alteration or special use permit and site plan applications for modifications of an existing single-family dwelling, the filing of any new application for the planning board review and approval must be preceded by pre-submission conference. So the pre-submission conference does not relate to a modification of an existing single-family dwelling, to lot line alterations, etc.
Okay.
Okay.
Thanks.
And that's always that note at the end of the agenda, the information for present and future applicants, which spells out the submission requirements and also spells out when the next meeting is going to occur and when the agenda deadline is, et cetera.
And I've read that too, but if it's a multi-family dwelling, automatically, even though it still might be a simple,
It requires.
so bottom line, they require the extra $250 fee, and then they're just going to come in and say, look, Art, now all we're doing is changing this right here, and you're done in 5 minutes. Isn't it possible we can have some wiggle room?
Well, the other thing you've got to realize is that any deposits that are put into an escrow account, if there are balances in those accounts, those dollars are returned to the applicant.
Oh, so it's still...
So it may be that there's $150 and there's a 15-minute charge against it or whatever.
Okay, I get it.
And if you go over those fees and costs, is that then another surcharge put on?
Actually, the bottom line is after pre-application, you're going to presumably move into the application process if you're proceeding, and you would be subject to application fees and escrows and things that are involved with applications. And that's all not established. Those numbers are not established within the zoning law. Those numbers are established within the building, zoning, planning fee schedule that's generally annually established and reviewed by the town board.
Okay, so we're not going to be leveraged way out about it.
Well, and depending, what in theory is supposed to happen is with every new application, Donna, the escrow clerk, and depending on the complexity of the application, will ask any involved parties, including Art, potentially our engineer, potentially our attorney, to estimate what they feel their costs will be going forward. And we use that as the standard for establishing the minimum escrow that needs to be established. Donna does a really good job of watching the escrow, and if it's, for whatever reason, if it's taking longer, then she will get back to me or to somebody else and say...
It's like your Easy Pass thing. When it goes down, she says, I need more money here.
Pretty much that's the way it goes. And if you take, say, a big project, for example, like Grassmere that's ongoing, you can see that from time to time you're going to be asking for replenishment of that escrow. So there's some fluidity to it, and some of them are very simple, and then periodically Donna goes through and meets with me and says, is this done? If so, I'm ready to reimburse the remaining amount in the account. So
good. Okay. Page 23.
Okay, Richard? Yep.
Upon initial preparation of a required full EAF, applicant shall employ the environmental mapper found on New York State DEC website as an informational resource. So they must use the mapper.
They must
take it under advisement.
Under the seeker regulations, they must consult the DEC website for the essentially file information.
New York State?
Yeah, it's a DEC website for the file information that's available on their project. And the bottom line is that if an applicant consults the website, he'll typically find all the information on floodplain and endangered species and wetlands, et cetera, et cetera, et cetera, and reduce the amount of work that they need to do, research they need to do in completing an EAF.
But how do we know that they did it if it's just as an information, just as a resource?
Because if they do it properly, the form that they will submit is a form that's been partially filled out by the DEC service.
I've seen the new form, yeah.
And you'll know if they filled it out on that basis, based upon the typeface and everything else that's involved.
You're right, because when you take the course, you don't really have to do it. You just have to go.
Yeah.
Okay, yeah. I get it. That's it. Okay. Certificate of use, I guess. Maybe I haven't been paying attention at all.
Where are you?
Where are you?
I'm sorry, page 25 was the first mention of it.
Thank you.
It's the whole page, but it starts out on the top, and it's talking about fees with site plan review and fee paid for certificate of use.
Included on the current town fee schedule and not specifically indicated in the text.
So,
The certificate of use is required, and a fee for the certificate of use is required. It's not specifically mentioned in the text, and it's...
so the certificate of use is a new certificate, and it's the equivalent of...
No, it's an existing
It's an
certificate.
existing certificate.
It's an
right?
existing...
But it's not in our laws anywhere.
It's...
Let me just ask,
you know,
I'm just
it-
trying to
it-
understand. This is for the ZEO, and the other certificate of occupancy is for the code enforcement officer.
Correct.
Exactly.
Okay? So we have a new certificate that mandates that Ron has to go out to a site, visit it, and say, yes, you have my blessing, we're all done, you have your certificate of use.
That requirement already exists in the zoning law.
Okay?
The requirement for that already exists. It is being specifically mentioned in this section.
But it's required by everything that
That's
comes in
correct.
front of us.
That's correct.
Okay. And people are paying the certificate of use fee right now for
I would-
everything?
I would assume so.
I guess I just haven't heard that term.
I haven't
And
either.
and if they,
I haven't heard that term here.
you wouldn't hear it here. It's...
Well, if I don't give a stamped plaque.
It would come after any
no,
decisions by the
the-
planning board. This would be a matter for the administration. All of this is a matter for the administration by the CEO and the building inspector.
And so we'll be done, and everything will leave. Melody stamps plats,
Yeah, until, that's the end of the planning board. When Melody stamps that plat and...
And they pay their fee.
And sends it to the CEO and the building inspector, they can then do whatever their thing is.
Okay.
Until they receive that signed plan, they can't, they can't...
But my understanding is if the certificate, let's assume that we're done here and it's gone on and the building department has issued a building permit for X, Y, and Z, whatever X, Y, and Z might be that we've approved. The building department cannot sign off theoretically on that completion of the building until the certificate of use is issued, certifying that what was approved was what was built.
Who issues that?
That would be the ZEO.
That's a responsibility of the CEO, not the building
And
inspector.
what projects require a certificate of use or
everything in front of
All
us.
them.
everything?
Now, I will tell you that you will know how difficult it is. I mean, one of the big questions that came up repeatedly in this discussion was enforceability.
Yeah.
And we can't,
It was-
we can't,
You can't do it.
if,
Well, one of the requirements
Can't
is the
enforce the
submission of
zoning.
as-built drawings.
right.
So now I just finished building my house, and I put
As-built.
change orders all over the place. Now I'm going to go back to my engineer and architect and say, I need you to produce a new set of drawings that reflect exactly what we really did. That just doesn't happen in this day and age. So most people are going to say, yeah, we're close enough. But to do otherwise would impose a $5,000 or $10,000 fee on some of these projects to say, okay, here. And it would take an extra month or two before they could hand in a really accurate set of drawings and get the certificate of use and then the certificate of occupancy, right?
Okay.
Certificate of use is required before a certificate of occupancy?
Yes.
Certifying that it was built according to the approved plans.
Yeah, approved plan.
So this requires another inspection by the zoning enforcement officer, not the building inspector?
Correct.
Correct. And my concern with something like that is one visit by the zoning officer and one inconsistency in the set of plans that he has in his hand. And he says, nope, I'm not issuing the certificate of use.
Otherwise, it puts a liability on him, so,
Well, he's doing his job,
yeah, I mean, he has to do that. so.
but there's nothing wrong with what's done, it just doesn't match what's on the plan. And if he doesn't sign off, they
Well, then
don't.
there's
If
the
it
other
doesn't match the
extreme.
plan, if it doesn't match the plan, there is something wrong.
That's
And,
right.
Well,
and
not if-
and it was incumbent upon either the applicant or the contractor, whoever involved, to resolve that matter during the course of the project. If they wait until the end, the bottom line is, it's their problem.
Well, during construction,
That
things
never come
happen.
up?
Well, and
Yeah,
oftentimes
and
during
there-
construction, the contractor will come in and talk about the
We'll
things
talk
that are
about
happening.
things.
Sure.
And there is provision.
And fixing them is one thing.
There is provision for bringing a matter to the attention of the CEO or the building inspector, and they're being authorized in minor situations a field change.
Right.
Of some sort.
In fact, it happens very frequently.
But you don't say
Sure.
that, you don't say that to the end of the project.
Right, but you don't redo the whole set of plans every time there's a change either.
Well, the as-built requirement here only relates to commercial, institutional, or multiple family residential projects involving new construction.
I guess I missed that.
Yeah, only
Where does it say that?
for all commercial, institutional, and multifamily residential projects involving construction of new buildings, substantial additions to existing buildings,
All right, I'm good
or
with that.
installation of major site improvement. It doesn't relate to all.
Okay.
Unlike a lot of ordinances in which I've submitted plans under, et cetera, that require as-built for anything. The bottom line is you
Yeah.
get to the end of the project and you have to have a surveyor out there to establish that your building is really 100 feet away from the lot line and not 99.8.
No, I think they're a good thing. I think it's sometimes it takes months to get those as-built drawings
Yeah.
because they don't
But
really
it's for
finish.
major, it's appropriately for major projects.
Okay. Page 27, modify subsection A, paragraph 1, as set forth. Down towards the bottom of the paragraph, talking about 125, 105 zoning enforcement officer. All applications, okay, all applications, and I'm skipping down to the underlined
That
part.
require either a freshwater wetland permit, that one?
So I'm reading, all applications developed within an area of a wetland and its associated buffer have to be forwarded to the planning board.
For review under the wetlands law, yes.
So all applications. So anything that comes, anything that's done by the zoning enforcement officer, period, comes up to us whenever there's a stream close by. Even if they don't now, even if it's just a simple fence, if it's something he has to go down and it's within 100 yards of a,
100 feet.
No, this relates to wetlands, not streams. The stream provision is in 12540 and 12549 of the zoning law. This particular provision is a cross-reference to the wetlands law.
so my concern is only that there's going to be a bunch of referrals that otherwise would not be necessary to come
No,
up.
these aren't referrals. There is an absolute requirement under the wetlands law that there be a wetlands permit issued in these situations. So the ZEO it's not discretion of the ZEO, it's not an advisory situation by the planning board, it's a requirement that there be a wetlands permit.
So the addition of this text is really just to clarify and make sure.
It's to cross-reference this provision, so if someone looks at this particular section, they realize that, oh yeah, there's a wetlands permit required in addition to whatever may be required under zoning.
Okay.
So there's nothing new there.
Page 29, top of the page. Is there any reason why during this revision, something like a referral to our other house or town committees, like the Waterfront Advisory Committee, why it couldn't be changed to 28 days instead of 30?
Yeah, because in order to make that change, Town Code Chapter 118, Waterfront Consistency Review, would have to be modified by the town board. That particular law provides for the 30-day review. Furthermore, that particular law, the adoption of that particular law, Chapter 118, by the town board was a prerequisite to the the state's approval of the town's local waterfront revitalization program. So in order to modify that particular law, one would have to go back to seek concurrence of Department of State.
Okay. Page 30, top of the page. We've added generators as an accessory structure. Why is a generator an accessory structure? And why do we need to make sure that we add it as an accessory structure? I can only have 3 accessory structures on my property. Why does the generator have to be?
Remember, I think generators is, if you take a look at the rest of the list, just about everything, anything else.
Well, I'm asking because
okay, now generators are dealt with. You know, generators have been an issue here. You've said quite frequently, why in the world is someone required to get a special permit and a site plan review for a generator? That's dealt with in terms of the accessory structure modifications that are proposed here. One is that any accessory structure that's less than 50 square feet in either building footprint or footprint, building, what do you call it, square footage or footprint
Projected to the ground.
is exempt from the special use permit site plan requirement. And secondly, any such structure of less than 50 feet does not count against the number of accessory structures.
Okay, I guess I didn't catch that.
Yeah, that's back, you know.
I don't need to go back as long as that's what you're telling me.
Well, Woody, I think Woody will vouch for that because that was one of his major concerns.
Yeah, so if somebody puts in a,
So it can still have a
And it's
chicken
not
coop.
part of the 1,500 square foot limitation
okay.
either.
So if somebody puts in a generator like the one down at the Marin Rue?
That's a structure.
That's big.
structure.
Yeah, that's a structure.
And that's exactly the distinction we're trying to make here.
Okay.
Any limitation of a generator that remains on wheels?
Yes,
No.
there's.
You said portable doesn't count.
It's been addressed someplace in here.
I saw
That,
That's right.
the term emergency generator has been used, and that's an inappropriate term. Generator is a generator.
Yeah.
The bottom line there is that the generators that are structures are those that are not the portable ones that you pull out, you put in your garage and you pull out for quote emergency use.
Right.
These are the generator that's regulated here is the one that's permanently fixed.
Right.
And there's
But I'm-
someplace we deal with that in here in terms of fixed location.
I know I've built, 200 kilowatt generators on mobile platforms, and there's no restriction on them at all.
As long as they're
Okay.
portable.
No, if it's portable, they're
Even
not
if you need a tractor trailer to move it.
So you just have to get an old truck and put it on the back of the truck in your yard.
Drive it around the perimeter of your building, yeah.
whatever.
I think I'm done.
Hope we provided, an explanation for most of it.
You did, and I just wanted to make sure that I made my notes.
All right, are there any other comments or questions? I see a couple members of the CAB here now. You are moving forward with your review of this independent of, okay. I don't see why not.
Of course.
Art on page 1,
Page
one.
Page one, that's that's not part of the law, but, okay.
There was a comment made about, on May 13th, local law number 2, 2014, provides for the establishment of a special event venue as a special use permit. Could you just explain that, please?
That was the case in question that triggered this was the barn on the former Pitcher property.
Right.
And that particular land was reclassified from RC5 into the adjacent or almost adjacent ORP district, which was on the opposite side of Middle Road, and a new use created within the zoning table. Special event venue basically is for receptions and meetings and things of that sort. And if I recall, there was a limitation of 50 persons or
Yeah.
75 persons or something like that.
That's what it refers to.
That's what it referred to.
Anything else? Anyone? All right, I don't believe we need to take action tonight.
No,
This was for the purposes of...
you actually, there actually is, we want to do two things. One is have this opportunity for comment on the specifics of the local law, and there is a report of the planning board that needs to be submitted to the town board, and it's kind of like my comment about the environmental assessment form, where most of the environmental assessment form doesn't apply to an action which is principally ministerial. The points that need to be covered in that report fall within pretty much those same categories. I'm going to draft for you for consideration on June June 6th. It's going to be a one-page report that basically says that from the planning board's perspective, these changes do not involve matters of master plan consideration. They're not policy matters. They don't greatly affect uses that are authorized in any zoning district, et cetera. Title matters to be, and a lot of these questions simply relate to a more site-specific zoning, whether the proposed changes in accord with any existing or proposed plans in the vicinity of a project site. That's not the case here. What's the effect of the proposed amendment upon the growth of the town as envisioned by the master plan? Whether the proposed amendment is likely to result in an increase or decrease in the total zoned residential capacity of the town. Whether the proposed amendment is consistent with and furthers the goals and objectives of the town comprehensive plan. Whether such proposed amendment is consistent with the underlying objectives of this chapter, being the zoning chapter. What are the indirect implications of the changes in their effect on other regulations? Are there adequate school facilities, other public services, and other support facilities that exist or can be created to serve the needs of any additional development that would occur as a result of the changes? So the bottom line is, it's basically pretty much a not applicable situation, because the criteria deal with really a matter of proposed change in use, or substantial change in of a specific use or general uses that are authorized in the law. But the bottom line is the report needs to be submitted back from the planning board, and June 6th is timely to do that, in that the town board is having its hearing on June 13th.
And we'll see that in your meeting notes?
Yes, that'll be in the meeting notes.
Let's make a motion on that our planning consultant be authorized to write that document for our June 6th meeting.
A no-impact document.
A no-impact document.
Back down.
Can I have a second on that?
Second.
All those in favor?
Aye.
Opposed, abstentions, so we will have some minutes here. We'll have to, we will have some minutes. with Woody's. Okay. Anything else, folks?
Who was the,
Woody made the motion, Sharon seconded.
okay,
It's a unanimous vote.
yeah, consensus, what do you?
If there's no other business, could I have a motion to adjourn the special meeting?
So be it.
Woody, seconded by Eric. All those in favor?
Aye.
Opposed, abstentions?